Hi everyone, I'm Dr. Megan McNeal. I'm a clinical and forensic psychologist. Over the years, I have very often gotten the question, what does a forensic psychologist do? Many people think we're profilers, that we help law enforcement catch criminals. There are few of us who do that. It's not very common. Most of the time, forensic psychologists will evaluate the person after they've been arrested for some sort of criminal behavior. We do a wide range of psychological evaluations. I'm going to talk very briefly about a few of those evaluations. Just know there are far more evaluation types out there than I will address in this video. There are two different courts we might work in: criminal court and civil court, at the federal or state level. Civil evaluations might be related to a couple fighting over custody of their children, and a forensic psychologist might evaluate the parents and determine who the best parent fit is. Or someone who might have been in an accident, they have post-traumatic stress disorder, and now they're filing a lawsuit against the company that caused the PTSD. A forensic psychologist might evaluate that person to determine how severe the PTSD is and what services they might need. In criminal cases, the forensic psychologist will do evaluations usually to try to help the court answer some sort of question. The most common one is called competency evaluation, or aid and assist evaluation, or fitness to proceed. There are a lot of names to describe basically the same kind of evaluation, which is essentially, can this person effectively work with their attorney to resolve their case? And case resolution can look very different depending on the case. Sometimes they go to trial. Most often people take a plea offer and they plead out their case. But sometimes people come into the jail floridly psychotic. That could be due to drug-induced psychosis or an untreated mental illness. And in those cases, if someone is actively hallucinating and delusional, then they can't really effectively work with their attorney. So the defense attorney will say, I have concerns about my client. A forensic psychologist will go in, do an evaluation, and determine whether or not the person is not competent. If the client is not competent, then they are usually sent to the state hospital where they receive medication and training in legal concepts. After they're restored to competency, they get sent back to the jail, and then the defense attorney is usually able to proceed with the case. Another kind of evaluation is called mental state evaluation. And there are several different kinds of mental state evaluations. Today I'm going to talk about the insanity defense. If you're interested in other kinds of mental state evaluations, find me on Substack. I will be posting some training videos or just videos that contain some more information about the different kinds of mental state evaluations and cases I've worked on that kind of fit those mental state evaluations. Guilty except for insanity, or not guilty by reason of insanity, depending on the state a person lives in, the language is slightly different. But essentially it's the insanity defense, which basically means, was there a mental illness that caused symptoms that then caused this person to engage in some sort of criminal behavior? A really common example would be someone who has auditory hallucination, so that's hearing voices or music or whispering. Or do they experience visual hallucinations where they're seeing things that other people can't see? Are they experiencing delusions, so beliefs that aren't real? And usually there's a combination of those kinds of symptoms. And it could cause a person to believe that they are being targeted by the government for some sort of alien abduction conspiracy. They might attack someone in a parking lot because they believe that stranger is part of the conspiracy and is actually getting ready to abduct them. So if they assault that person in the parking lot, they're generally doing so to protect themselves from this imagined threat that is caused by the hallucinations and delusions. So the mental illness causes these symptoms that then cause the person to engage in the behavior. If a person is found to be insane at the time of the criminal behavior, a lot of people think they just get to go free and go home. That's not true. What happens is they go to the state hospital. And at some point, if they become stable enough, that person can work their way back out into the community. In some cases, that doesn't happen, and the person stays at the state hospital for a much longer period of time. Most people don't know that between 30 and 40% of people with mental illness actually don't respond to antipsychotic medications. So in some cases, they take the medication and it takes the edge off, but they're still symptomatic. In other cases, I've evaluated people where they take medication and it hardly does anything at all, and they continue to hear voices and have delusions and feel agitated. Very often, those people end up staying much longer in the state hospital. Another type of evaluation that is done in the criminal defense world is called mitigation evaluations. These are the evaluations I mostly do. I really enjoy these kinds of evaluations. They are a deep exploration of a person's psychological functioning, and it's essentially what were the psychological factors that contributed to this person's behavior at the time of the criminal offense. And very often it's a combination of factors, but the common trajectory I see is trauma history in childhood, early substance abuse, and then this combination of substances and mental health problems that then lead the person to engage in criminal behavior, and then they're incarcerated, and there's this cycle of trauma, substance use, incarceration, and then they get to a point where they've committed a really big offense and are looking at a lifetime in prison. People commit crimes for a wide range of reasons. Mitigation evaluations can help the prosecutor and the judge better understand the reasons why this particular defendant keeps getting into trouble. Women in the system tend to offend for different reasons than men do. My particular area of expertise is female defendants who are charged with serious crimes. So, a common kind of scenario for a woman in the system would be someone who, I'll use an example of a woman I evaluated early in my career. She was charged with bank robbery after she took a note into a bank that said, "Give me the money, I have a weapon." And then she left with the money and she was later arrested. A lot of people don't know it's really easy to rob a bank. You basically give the teller a note that says, "Give me the money, I have a weapon, have a nice day." The clerks are told to give the money to the bank robber, who's then usually later apprehended. And then they're looking at many years in a federal prison. When this woman was arrested for bank robbery, she was told she might get 6 or 7 years in federal prison. And over the course of my evaluation, we found that a couple months before the bank robbery, her boyfriend drove her to the bank, gave her the note, and said, "Go in and rob that bank. Go in and get me some money." And at that time, she said, "No way, I'm not doing that." This woman had no criminal history. So the boyfriend takes her home, beats the daylights out of her, throws her through a coffee table, She goes to the hospital for treatment, comes home. 2 months later, he takes her back to the same bank, gives her the note and says, go in and rob that bank. And so she does. As part of these mitigation evaluations, I ask the defense team, or I myself will get collateral information like medical records, school records, talking with collateral sources like family members, work supervisors, teachers from school, that kind of thing, so I can get a better idea of who this person is. In this case, we had medical records from that assault that had happened 2 months prior when her boyfriend beat her so badly she had to be hospitalized. So we obtained those records. I also was able to speak with her mother, and her mother told me that there were many times when this woman had tried to leave the abusive relationship, and the boyfriend called the mother's phone and left abusive, threatening messages on the mother's voicemail. She had the wherewithal to keep those messages and was able to play them for us and later on for the judge. This woman had major post-traumatic stress disorder. She was a victim of pretty severe domestic violence for years, and she was terrified of this guy. So what the judge realized over the course of this mitigation evaluation and the report I wrote was that this woman was not criminally minded. She was basically trying to keep herself safe from this person who wanted her to go get money for him. Mitigation evaluations can result in negotiating the charges down to lesser charges or a lesser punishment. So instead of getting 6 or 7 years in a federal prison, she was able to negotiate her charges down to the point where she had essentially a misdemeanor offense and she got probation, and she went into DV treatment. She went into a shelter for women who were victims of domestic violence, and the federal prosecutors worked with state prosecutors to file charges against the boyfriend for assaulting this woman so many times and causing some pretty severe damage. Sometimes a case can resolve like that. Sometimes it doesn't. Sometimes the mitigation doesn't really help and the person is charged with serious crimes that they end up spending many years in prison for. So it can just depend on the kinds of mitigating factors involved, who the judge is, who the prosecutor is, and who the client is. If you're interested in more of these videos, please hit like or subscribe, and also find me on Substack. I will be posting training videos to my subscribers and more stories about a lot of the work I have done over the years. Thanks for watching.